Lords, my ladies. So we were going to turn then to the definition of consideration in the agreement, page 17, the call option. And we can see there are three ways in which consideration can be calculated, and they are, at least at the face of it, in the alternative. It's either A, B, or C. Clearly, it can't be A and B because A and B are mutually exclusive. The question is, can you, in a transaction involving more than one element, lump B and C together? They are all directed at an extrapolation of the value of 100% of the club based on the price payable. A, of course, one doesn't need the extrapolation because that's 100% disposable. B and C are both, and the process of extrapolation for C doesn't differ from B. So, notwithstanding, I accept that it's likely that an call option will be sold at a lower price than the full consideration. There doesn't seem to be any distinction between the two. One simply works on 100% notional value of the club based on the option, the option sale price. So that's consideration. That then obviously feeds into adjusted consideration. Then we have the ratchet, what we call the ratchet mechanism, and that comes under the definition of agreed percentage amount, and that is at page 112. Now, bearing in mind that clause 20.11 explicitly says that it's only for transactions where the adjusted consideration exceeds 125 million, what this says and means, and its common ground, is that obviously the more value you extract from the shares, the more that is payable by way of sharing the spoils. But nothing is payable if the adjusted consideration is less than 125 million. So nothing is payable if the notional value of the club, by reference to the transaction in question, falls below 125 million pounds.
Before we look at that and move away from consideration, isn't the issue is that you say that each of A, B, and C are looking at getting to 100%.
Yes.
And I see that with A and B, and I see it with C in relation to the sale of shares pursuant to the option. The problem with the option, the consideration for the option alone, is A, it won't or may not equate to 100%. It won't give you the value of the company at 100%. But also, there is the sale of shares.
Well, only if the option's exercised.
Well, but surely we're looking here at, well, certainly in this case, we're looking at a situation where it's not exercised.
Exactly.
So we're not, are we, dealing with an exercise of calculating 100% of the company's value based upon the share option price?
You are. Take the simple example where there's no disposal involved. It's simply the grant of a call option.
Yes.
I don't think there's any dispute that in that instance, one would just simply look at C. One would extrapolate the value of the company based on that option price, and then feed that figure into the ratchet.
Well, I agree that's what it says, but it doesn't make sense, does it?
Well, I'm not sure why it wouldn't make sense. Because the shareholder has extracted that value. think your lordship may be presupposing it's unlikely that the option price will be less than the equivalent threshold amount, but one can't possibly assume that as at the date of this agreement. This was a long-term agreement. I think the qualifying period is 10 years for these transactions. So one can possibly assume that the option price would always be below the threshold amount, and it would depend on the strike price. As my learned friend points out, if you have an option that can be exercised at £1, for example, obviously the value of the option very close to the value of the club perceived at that stage per share.
If exercised.
If exercised. Yes.
If not exercised. So if it's a price for the option, which is, as in will often be the case, it's a much lower price than the price for the shares.
It can be.
Yeah, and if it is, then no one would suggest that extrapolating the price per share for those shares subject to the option to all the shares in the company would give you, in fact, the value of 100% of the share capital in the club. But that's not the point. It's a completely notional calculation.
I agree. I'm not seeking to argue that the notional price based on the option price for 100% of the club is equivalent to coming up with a value of 100% of the share value of the club. I'm not suggesting that, obviously not.
So although it says that, it obviously doesn't mean that literally.
Well, it says an extrapolation of the value of 100% of the share capital of the club on the basis of the consideration paid for the shares sold of the consideration to be paid for the option. So my submission, that is what it says. It's saying it's 100% of the value of the club, but based on that price of the option. It's common ground here that what the parties are agreeing is that if a shareholder extracts value from the shareholding, they have to account for that value subject to certain rules. And there's nothing incongruous about saying, well, if you extract value by way of an option, you look at the amount of the value you extracted for the option.
But the point is that if you have an option price, which is where the option is not exercised, you're not selling any shares at the end of the day.
No, you're not, but you are still extracting value.
But in that case, you can't extrapolate to 100% from, say, 10% because the shares have been sold.
No, but it doesn't say that. It says that what you do is an extrapolation of the value of 100% of the share capital of the club on the basis of the consideration paid or to be paid for the shares sold of the consideration to be paid for the share option.
All the consideration.
Well,
Yes.
as I understand it, the parties read the word "of" as all.
They do. That's a typography.
But see, if you're talking about the shares, then it's the consideration for the shares. You can extrapolate from the shares what the price is for 100%.
Yes.
Because it refers to the shares.
Yes.
But consideration for the option, you can't extrapolate that to 100% because it is not relating to a price per share.
This isn't a point ever raised in this case to date, that subpart C doesn't make any sense.
Well, it makes potentially more commercial sense in the case of an exercised option,
Yes.
where you might, I know parties have interpreted "of" as all, but one reading might be if the option's exercised, you look at both because the value of being extracted from both the grant and the exercise.
We've always conceded that. We have always conceded that if one was dealing with a two-stage process where there's the grant of an option and then the subsequent sale, that you lump the two together. But it doesn't arise in this case.
But so taking on, you say, well, contrary to that, what this is designed to do is to look at the value the shareholders are getting by the transaction, by
Indeed.
getting the option price.
Indeed.
But on your and the judge's analysis, ultimately, that doesn't result in any share purchase amount because it's below the threshold.
But only because it's below the threshold.
Yes.
If it were for a higher amount per share, we'd have had to account for it.
But that does mean then that it would be very, very easy for the shareholders to say, well, rather than, and the purchasers to say, rather than including all of the consideration that we're going to get in the share price, we'll put a chunk of this into an option.
No, because
Which we won't exercise.
No, because we've conceded that, well, if it's an unexercised option, there's no hardship because the shareholder has not extracted more than the threshold value from that transaction. If it's an exercised option, something funny going on, whereby you try and split the consideration.
No, but even if it's an unexercised option, they say they want to sell 100 shares, or they still sell 100 shares, but then they also agree an option.
Over the same shares?
No, different shares.
Well, then there's no difficulty because we know the way this formula works, which I will develop, is that there is no anti-avoidance problem because it doesn't matter whether you did the ratchet for each individual share. So the 187 shares.
But it does matter. I mean, this case is an absolute example of it, in that these shareholders got an extra 18 million for one and the same overall linked commercial transaction, but don't pay any premium for it. Which shows exactly, and that's exactly why the expert says, well, we've got to do something about that. And the way we deal with it is the way he dealt with it.
Can I answer that in due course?
Yes, of course. Sorry, I'm not letting you
run
your arguments.
It's one of these cases that if I fail, I'll fail because I failed to explain adequately how this formula works. But it's one of these cases that once you sort of understand the point, understand that my learned friend's anti-avoidance argument is just wrong. Once one sort of gets all of that, then one comes out where the judge came out, which just can't work. But it really would be more helpful if we do it.
Yes.
In a
you carry on, and I will.
Way. Got to finish.
Keep quiet.
To give my friends some time to reply. So that's considerations. We feed it then into the ratchet, the agreed percentage amount. That's at page 112, which we were just about to look at. We don't need to look at that in any detail. But suffice to say that if one understands this, as we suggest it should be understood, which is that this banding is applicable to the notional 100% figure, then it makes perfect sense, because what the parties are saying is that if the value that you extract for these shares, once you extrapolate it out to 100% of the company, if you go above these particular banding levels, you have to pay the percentage stipulated. Then one comes to the final stage, which is the stadium premium amount. Now that's at page 133. We haven't really looked at that, but this is quite important because this is now the reversal of the extrapolation process. So the mathematical formula that was required by the extrapolation process is then reversed by the stadium premium amount, and that says it's the agreed percentage amount. So that's the fee payable on the basis of 100%, multiplied by the ratio of A to B. A is the shares or rights to shares in the club, then the subject of the qualifying transaction, and B, the total issued shareholding in the club. So just taking a simple example, you sell 10%, you multiply by 10 before you feed it into the ratchet, you get the fee, and then you divide it by 10. Now, mathematically, that is exactly the same. It could have been exactly the same result could have been achieved by saying we will divide the number of shares that are the subject of the transaction by the number of shares in that transaction. So take it down to the value per share, then feed it into the ratchet, then afterwards multiply by the number of shares in the transaction. That would be exactly the same mathematical formula, just slightly retweaked. Now, if it's
the judge did it both ways in his judgment, didn't he?
Yes, I think he did. But if one thinks about it in that way, what the threshold amount is saying is that if the amount per share is below 125 million divided by 3438, which I have the figure somewhere, at 36,358.34. What the parties are saying is if you get less than that per share, there's nothing to pay. And that applies whether it's an option or an outright disposal. So we're not saying that the option's immune. We're not saying you don't get to pay anything. What we're saying is that applying and understanding this formula correctly, the option price wasn't such that it fell within the bands. And there's nothing odd or surprising or unfair about that, because it is common ground, and the expert found as much, that if it had just been an option, there would have been nothing to pay. Or if the option and the disposal have been separated by days or months, whatever the figure might be. The agreement is all about extracting value. Now, this whole mechanism is actually aimed at anti-avoidance. Far from this being vulnerable to some clever scheme, the whole point of the mechanism is that it should not matter whether you break down your transaction into small parcels or not. As I've pointed out, if you carried out the disposal by 187 different individual transactions, you still have to pay the same amount. That's because of the grossing up and then the pro-rating down. And that objective is explicitly stated in the agreement. I think I'll just pick this up. It's in the schedules, and that's in, it comes behind the agreement, Schedule 15, the worked examples.
T1.
Yes. This is the mathematical proof. Multi-tranche sell down versus single transaction. And well, it starts at 220 because the same disposal is treated as either 3 separate disposals of 20% or 1 single disposal of 60%, and it comes to the same answer. And that would apply whether it wouldn't have to be 20%, it could be even smaller parcels. You could do it by individual shares.
Yeah.
Now,
but it always works if there's the same price per share.
will it always work if
These examples assume?
But it would always work if our approach to the transaction had been accepted by the expert, because we would have said, you look at the share option, you feed that into the ratchet, it doesn't meet the thresholds, there's nothing to pay. That's the parties' agreement. We didn't extract more than the value per share.
Oh, you can argue this both ways, can't you? Can't you say that the schedule indicates that the parties didn't intend that having different elements to a transaction would make a difference?
Well, what it certainly indicates is that it shouldn't make a difference. But what we see with the expert's approach is that all sorts of factors now will make a difference. I mean, my Lord Justice Phillips' point about what if you have the share disposals are at different prices. I mean, that will massively distort the amount, because what you will find is that if you have 2 lots of 100% notional value, the second one, whichever it might be, will all fall in the 20% bracket, the top band of the ratchet. Whereas if they're the same price, it won't.
It depends on how you do the calculations with all these things.
Well, it shouldn't do. It shouldn't do. No, it really shouldn't do, because if you do it in the way that we suggest is the correct way, that £1 difference will result in an increased stadium premium amount, reflecting that £1, but not in any way that's distorted. But if you do it Learned Friends way, you end up feeding 2 lots of notional value into the ratchet.
Well, I wonder, I know that's the way he put it, but I wonder whether that is the way it would have to be done. Because the The
Yeah.
problem is that the consideration clause just doesn't deal with it.
I mean, can I just, on your particular point about selling shares at different prices, there is an approach that doesn't involve what you say would happen in that case, where you just go to the definition of consideration. You say, I've sold less than that. You know, assume we've sold 60% of the club at 40% at one price and 20 at another. Perfectly legitimate interpretation of subparagraph B to say, I've sold 60% for an aggregate price, and then I feed that into the
You
calculation.
could do it that way, or you do it the way that we say, is you can break it down into more
But
than
it's
one.
there's not even a stretch of the language to do it the way I've suggested.
What the aggregate value?
No, yes, 60% for the total price for that.
It'll come to exactly the same result as the result we say is the correct way, which is to view it as two qualifying
It
transactions.
won't, would it? Because if you
No, because one may be at a different price per share that gives you an implied value below the threshold.
No, because then you won't pay anything for those shares anyway. The way the formula works is that it's dependent on the value per share exceeding that figure of £36,000 pounds.
But where does it actually tell you to look at the value per share?
It doesn't. I'm submitting that that is the mathematical equivalent. That you can rewrite this formula in a slightly different way, but has exactly the same result. And the reason it's helpful is because one can see what the parties were getting at. One can perceive the intention of the parties. My position is it's not a hard case. There's no funny business being alleged ever against us. It's always been accepted that these are straightforward arm's length transactions.
I understand that. Sorry, I'm starting on the same hobby horse. I understand that in relation to shares, and even if they are at different prices. But if you have a sum which is outside of sales, there are no sales of shares, but there is a sum which is contemplated within C, that is an option price,
Yes.
which doesn't result on this hypothesis in a sale. The shareholders are getting money. It is not attributable per share sold because no shares are sold, and yet that does not result, it is not reflected in the fact that the shareholders are getting a higher consideration in total than is reflected in the mechanism as you would have it.
If I said the price per share sold, what I meant to say was the value extracted per share, just to be clear. But yes, that the formula says that if the value extracted per share, however you extract it, could be an option, could be a share sale, could be anything. It's very broadly drawn. If the value extracted per share transaction, per dealing in the share.
There isn't a share transaction with that's the point, that there isn't a share transaction for this 18 million.
No, but there's a transaction in the sense that there's an option granted.
Yes, but no shares exchange hands.
They didn't in the event.
No.
That's true.
Well, if they do in the event, then it's easy because then you have the formula of 100% based upon the consideration paid or to be paid.
But Lord, that is common ground that other than the blended aspect of this case, that's exactly the way the formula works. So,
but it isn't, because what the expert did, and what I understand was E20's submission, is that the 18 million is effectively treated as an additional factor in the calculation, even though no shares exchange hands.
It's calculated as being part of the consideration capital C for the disposal.
But not in the same way as though it was just another sale of shares. Because if it was, as you say, it would have to go into the mix as a price per share.
We'll test it this way. Let's assume that we are just dealing with an option transaction. There's no disposal involved at all.
Yeah.
And assume that the figures are all the same as in this case. I understand it's common ground that there'll be no stadium premium amount payable because the 18 million grossed up to the 60 million doesn't exceed the 125 million.
Yeah.
So why is this case any different? Why does this case make all the difference that you lump them together and come up with this?
Because in this transaction, and that's why it matters whether it's one transaction or two transactions, in this transaction, the shareholders selling the 187 shares got an extra 18 million.
No, that's the problem, you see, because apart from the parties not being the same, but the problem with that is what you'd have to find is that consideration of 18 million was attributable to 187 shares, and nobody has ever alleged that. I agree with your lordship. If that were the case, then in fact the findings were, or the assumptions were, that the 18 million was not attributable to the 1,022 shares, but to the 187 in some way. I agree. Then you would have to work on the extrapolation based on the true consideration for the 187. But nobody's ever suggested that. Everybody's accepted that the consideration for the disposal is what it says, and the consideration for the option is what it says. Now, once that concession is made, there is no basis then to cross-refer the consideration over.
Well, it's the expert's way of giving effect to the commercial reality that they got the extra 18 million.
Can we look at what because that's not what the expert was doing here. Your lordship, is my respectful submission, attributing to the expert a sophistication of analysis that is not true. I'll look at it in due course.
Before you go on to that, can I just take you back to your sale of two different sale of 100 shares, but in two different parts?
Yes.
Your case is that the 125 million threshold figure, you can look at that as a per share figure.
Okay.
So let's say the per share figure is X.
Yes.
And 100 shares are being sold, 50 at just above X, 50 at just below X.
Yes.
By definition, if you separate that into two different transactions, one of them does not reach the threshold, the other does, doesn't it?
That's correct, yes.
So in which case, if you did it by two separate analysed it as two separate transactions, you would have a significantly lower.
No, because what's helpful is to think of the process as being the way I suggested it could have been done, which would be that you feed the price per share into a ratchet that would be different. So what you would do in that instance would be you'd have, let's say, 100 shares at less than the 36,000 per share. They would attract no share premium. 100 shares above it. So you would then trigger an agreed percentage amount on those shares, which you would then multiply up by the number of shares concerned, which would give you mathematically exactly the same answer. My Lady Justice Falk indicated if you'd done some sort of pro-rating across the two.
I'm not sure that that's right, actually.
Yeah, I'll explain why it is right.
Okay.
Let me try and explain. It's very difficult with maths. Better with a spreadsheet in front of one. Let's just assume that the first parcel is sold exactly bang on the threshold. Okay, so that there is 0 to pay. And the second parcel of shares is sold at £1 above the threshold amount. Now, if you calculate them separately, you will get 0 plus the bottom band of the ratchet on the £1 times the number of shares. And the bottom band of the ratchet, I think, is 7.5%. Yes. But if you did them prorated, what you would end up, averaging it across, you'd end up with a single transaction at 50p above the threshold, times 7.5%, but times double the number of shares. So you get exactly the same result. The parties were right in Schedule 15 when they said if you operate this mechanism correctly, it should not make any difference. Now, I think your Lordship's lady will have the point that or is actually an important word here because it prevents this double aggregation. It prevents you inserting more than 100% notional value. And if one takes it to the extreme suggested by my Lord Justice Phillips, where you have, say, 2 or even 3 different prices of shares, if every single one gets fed in to the ratchet at 100%, a fresh 100% notional value, what will happen is that the second, third, fourth, whatever, will start to attract the premium at 20% because they will all fall in the top band, or most of it. Whereas the intention of the parties was not that. The intention of the parties is that the bands apply dependent on the value being extracted per share. So, now, can we look at the disaggregation problem? Because where the experts' approach further runs into difficulty is when you're left with this single agreed percentage amount based on double the notional value of the company. Because what you've got to then do is work out what the stadium premium amount is. And the stadium premium amount definition, we'll just go back to that. That is at page 133. The stadium premium amount means the agreed percentage amount. So this will be the super figure based on 2 lots of 100%. Multiply the ratio of A and B, where A is the shares or rights in the club that are subject to the qualifying transaction. So if that's right, that will be 1,022 plus 87, plus 187, I should say. So that's roughly 1,200, thereabouts, divided by the number of shares in the club, which is 3,438, so just over a third. Now, can I take you to Annex A to our skeleton? Because what we've done is set out what the experts' calculation involved.
Before my learned friend takes you to this is not in fact what the expert did. It's what my learned friend would like to think the expert did.
It's exactly what the expert did. If one looks at the figures, they all work. So anyway, so stage 1, both the share disposal and call option are a single qualifying transaction.
So what page are we on, sorry?
Page 59, I'm so sorry, it's tab 4, page 59 of the core book. All that we've done here is explain the expert's mathematical result and then work through the process that has been used.
Just before we do, I don't disagree that you may simply explain it, but just to go back to something I said this morning, as I understand it, different mathematical approaches were not put to the expert.
That's true.
So,
That's
for
true.
example, in the middle of this page, you say you would get it to a different result if you plug the premium into the bottom of the calculation rather than the top. I don't understand any of that to have been before the expert.
No, it wasn't. That point wasn't before the expert. The way it was argued before the expert was that if you look at the contract and you look at the scheme of the calculation, this is obviously not the way you do it. We didn't look at the various fully. Some of them we did, but not fully all of the problems with that approach. But in my submission, it doesn't matter because what the court and the judge was concerned with is the expert's determination manifestly wrong. So,
Well, just to pause on that, the scope of the dispute or the nature of the dispute as framed to the expert must inform, must it not, whether he made a manifest error?
I'd agree with that, but the dispute was what was the stadium premium amount.
Well, you could frame the dispute as put to him was that the choice was between 0 and 3.6 million.
On light. Can I
Yeah.
go back to the
Okay.
calculation?
So
So stage one, both are a single qualifying transaction. Stage two, consideration is therefore, and these are the figures, so 25,000 odd per share for the disposal, multiplied by 3438 divided by 187 gives 475 million as being the capital C consideration for the share disposal, plus 18 million for the option times 3438 divided by 1022 gives 60.5 million. That's the equivalent extrapolation for the option. You don't deal with them separately, you add them both together and you get 535,552. Then there's adjustments at stage three, which are we don't need to concern ourselves with. And then at stage four, you feed the 535 million figure into the ratchet, and these figures are slightly different from those on the agreement because the expert used the inflation adjusted figures. All of the bands, save the threshold amount, increased with inflation, and nothing turns on that. Those figures were all agreed. And that gives one then an agreed percentage amount of 58 million odd. Now, what you have to do then is disaggregate the 58 million. You've got to work out how much of it is attributable to the share option, how much to the disposal. But actually on the face of the agreement, you don't have to do that. On the face of the agreement, you simply multiply that figure by A over B. And so if you multiplied that figure by A over B, you'd end up with a figure of 20 odd million. You'd apply the ratio, it'd be 1209, that's the 187 plus the 1022, and divided by 3438, multiplied by 58 million odd, you end up with a figure of 20 million. Now, that's what the expert's approach requires on the face of the agreement. And one asks rhetorically, can that be right? I mean, not even E20 have ever suggested that that's the correct figure. That's obviously wildly high. But that's the actual figure that you come out with if you apply the ratio A to B consistently with the definition. But what is in fact done, or what E20 now London Stadium say you do, is that you will split it. And as my Lord Justice Phillips has pointed out, how you split it itself makes a material difference. The way in which it was split before the expert was to say that the first 46.5 million is attributable to the share disposal, and the top 12 million is attributable to the call option. Now, there is no contractual basis for this disaggregation at all. Nothing. There's no contractual basis to add them together, and there is no contractual basis for this disaggregation. And then what you do is you apply two different A to B ratios to each disaggregated element of the stadium premium amount. So you apply the 187 divided by 3438 to the 46 million, that gives you 2.5 million. And you apply 1022 divided by 3438 to the 12 million, and that gives you 3.6 million. And then you add them together to come to the 6.1 million. So if you are entitled to aggregate and blend, you have to then read into the agreement somehow a disaggregation process. And the Lord Justice is right to say that it all depends, the result will depend on which way round you do it. For this reason, with the option in this case, that was getting on for a third of the company. So the A to B ratio will be much higher, obviously, than the share disposal A to B ratio. So if you say the option comes first, i.e. the first 18 million of the agreed percentage amount is attributable to the option, then 0 is payable for that. And then if you then say the second amount is the top band, you end up with a total figure of 3.1 million. Now, I accept, I know the lady's going to say, did you say that in front of me? No, we didn't. We adopted a very simple approach, which is to say this is all wrong. This is plainly wrong.
As I make sure I've understood, your approach before the expert was one way or another. You have to look at the option and the share sales separately and apply the formula to each separately. And really that was the beginning, and I know you may have put it in more than one way, but that's the gravamen of your argument, wasn't it?
Yes, there were 2 points we made. I'll show
Yeah.
the court what we were saying. But we said it's not one qualifying transaction, because if you look at the way the formula works, and the expert found it is one transaction, and commercially we've accepted that he was entitled to come to that view. But secondly, we said you can't read or as and. It results in absurdities in the calculation. And he never dealt with that. And I'll show your lordships and my lady why I say that.
So you just said that. You say commercially that was right. So you are no longer disputing, you're no longer saying that the expert was wrong to say that this was one qualifying transaction.
We say he was wrong to, and we've always said he was, even though he's entitled to say commercially they're linked.
Yes.
One wouldn't happen without the other. He's entitled to do that. What he wasn't entitled to do was then use that and apply it to the formula as stipulated in the agreement in the way that he did. That's always been that position.
But can I understand what you mean by that? Do you mean by that we therefore, the only way of interpreting this agreement is to treat that as having been 2 qualifying transactions?
What we would say is the only way you can really make this formula make sense is to do it that way, because the alternative gives rise to so many absurdities.
Well, can I just possibly repeat the question? If there is one qualifying transaction, then you've got to choose on your approach, when you have to sort of choose which set of consideration you look at.
No, he's
just
absolutely
want to make
right.
sure I understand.
That's
your
right.
argument.
And my recollection is one stage in the argument before the judge that was suggested, but that's never been our position before the expert or before the court. We don't accept that you can get out of paying a stadium premium amount if the threshold amount is crossed for any aspect of the transaction.
I think, certainly from my part, I'd really like to nail down the question. Do you accept that this was one qualifying transaction within the definition in the agreement?
A single qualifying transaction?
Yes.
I do not accept that one can apply a single qualifying transaction to the consideration calculation.
That's the question.
But
The definition.
but forgive me, that's not really answering the question. I mean, the agreement has the concept of a qualifying transaction. And as I understand it, you said that you accept that the judge was entitled to say that this was commercially one transaction.
Yes.
I think I'm entitled to press you to know, do you accept that this is a single qualifying transaction within the definition in the agreement?
Well, does this answer the question? That in this case, you cannot make this formula work by approaching these elements as a single qualifying transaction.
With the result that it's not a single qualifying
For
transaction.
the purposes of consideration, yes.
So I'm not quite sure
Well,
what that means, because either it is a single qualifying transaction or it isn't. It seems to me.
Well, can I explain?
Because the only purpose for which you have a qualifying transaction is for the purposes of applying the formula to that transaction.
Well, if that's right, then I accept it for all purposes. I'm not sure that is right. But can I just show Your Lordship what I mean by reference to the definition?
Yes.
So if one looks at page 117, consideration means for a qualifying transaction, A, B or C, if one's dealing with a blended transaction, so there's a disposal and an option, the only way that one can make this work is to view the disposal as a qualifying transaction under B and the option as a separate qualifying transaction under C. But I'm not seeking to suggest that the expert was not entitled commercially to take the view that these were linked small t transactions.
But that's irrelevant, other than insofar as it's relevant to what is the qualifying transaction referred to in this definition.
Well, maybe irrelevant for the purposes of this appeal. I'm not sure it's irrelevant for all purposes, but well, yes, we say that you can't make this formula work by viewing the qualifying transaction.
Well, that depends on which way you approach it, can't you? You can say this formula can't work, so therefore it can't be a qualifying transaction. But if you start from the premise that the judge was right to say that it was a qualifying transaction, then the judge has to try and make the formula work by purposive construction and or implication.
Well, what the expert did, as I'll show in a moment, was to take the view that this was determinative. The issue of whether it was one or more transactions was determinative, and that wasn't the position before him. I'll show you. That's why I stood up earlier to say that wasn't.
But you seem to. I mean, I think it's clear that. I think even on Mr. Rabinowicz's case, is if it is two qualifying transactions, then he loses.
Yeah.
So, but the question then is, well, if it's one qualifying transaction, where do we get to? I think you say I don't lose, but the way you don't lose is you say, by interpreting, when you come to consideration, it has to be two qualifying transactions.
But what I'm saying before this court, I think exactly what the judge found, is that he said that we succeeded on both grounds, the second being the qualifying transaction point, but because of the way you read and apply this clause, and that's all I'm seeking to
I entirely agree. I do understand the judge said that. It seems to me you're slightly trying to have your cake and eat it.
Well, I hope I'm not guilty of cakeism. I mean, forbid. But what we would say is, of course, I accept factually the expert's entitled to take the view on the facts. This and we've not ever sought to advance the manifest error complaint on that ground. But what we do say is that if you understand how the formula is intended to work, it becomes impossible, it's unarguable, that you can lump together two, whether they be two considerations in the same qualifying transaction or two considerations from two different qualifying transactions, doesn't matter. You can't add them
again,
together
forgive me,
in this
but putting
formula.
it, I've just put it to you again. It does depend which way round you approach it, doesn't it? And you, and what one has to come to is an overall interpretation of the agreement, looking at the competing interpretations and applying the usual iterative process. And you're allowing this definition of consideration to drive what's a qualifying transaction, but you've also got to look at the other way around and see, well, hang on, if it is one qualifying transaction for the very good commercial reasons the judge indicated, then how could we make sense of consideration? You have to look at both, don't you?
Well, I think I would agree with that up to a point, but what you can't do is then engage in processes that are mathematically nonsensical. So it's not, we would say it's mathematically nonsensical to have 100% notional value for
A manifest error.
I'm so sorry.
But is it a manifest error?
Well, obviously we say it is, and the judge was persuaded it was, and the judge was
Well, that's why we're here.
was very, very conscious of the high threshold. But can I follow it through and then look at the expert determination? That's my next heading, actually, looking at the determination itself, and that's in the supplemental body of tab 7. So, Lady Justice Falk said rightly earlier that the expert seemed to assume that the qualifying transaction point was determinative of the dispute. And we see that from paragraph 25 at page 58. As noted above, the issue between the parties is whether the transaction for the sale of the 187 shares and the grant of the option for 18 million amount to a single qualifying transaction. And that was not common ground. It wasn't common ground, that was the determinative issue. Can I show the court the note of the hearing at tab 6? And then page 49. And if the court would look at the bottom hole punch, there's a numbered 6. And I'm saying there is a mathematical problem with double counting. 100% of the shares is calculated twice on that case. Even if you can link them together and say they're one qualifying transaction, you're still double counting. That's a freestanding point. So it wasn't right to say that it was common ground that a determination of that point resolved the issue. That's the first point. The next point is at paragraph 37. In dealing with the or versus and point, last 6 lines on page 64 of paragraph 37, I'm sorry. Furthermore, the definition of consideration in relation to a qualifying transaction requires the application of A, B, or C to each component of a qualified transaction if there are more than one, and in this case requires the application of B and C, which some might think is a non sequitur. To say that the contract requires or, either A, B or C, therefore it's and B and C, we would suggest is a non sequitur. And then 38, again, it's the same point. There is no dispute between the parties as to the effect of the option agreement being treated as part of the same qualifying transaction as the sale of shares. The additional sum must be paid. Well, that's just not right. There was a dispute, and I made that clear. Well, what the expert never did is he never got to grips with the actual mechanics of the way the formula works. The extrapolation stage, the ratchet, and then the prorating down. The inherent logic that the same ratio by which you extrapolate up should match the ratio by which you prorate down. Never dealt with that. Can I deal with Benyon at this stage? The and means or the or means and. Benyon's not actually saying that if one looks at it with some care. That's, I think, tab 15. I do accept context is important in all these cases, no less in this case. But what's being said here is not that or can mean and, it's something rather different. And it's helpful to look at the example. So the comment, my learned friend took your lordships to, my lady too. But the third paragraph down, page 284, here is an example where it's held that or was to be read in an inclusive or conjunctive sense. But when one looks at the case, one can see actually what was going on here. In Pilling and Reynolds, the provision stated that ballot papers which had been marked A, elsewhere than in the proper place, or B, otherwise than by means of a cross, were not deemed to be void if the voter's intention to vote for a particular candidate was clear. The divisional court held that or was to be read in an inclusive sense, so that the provision applied to a ballot paper marked in both of those manners. One can readily see how that would be the case in that situation. If you say that a ballot which satisfies this criteria need not be void, or this criteria need not be void, if a ballot paper satisfies both of those criteria, one can well see that the correct interpretation of that statute is to say, well, nevertheless, it's not necessarily void. You look at the intention of the voter. That's what all that is saying. So if you were saying that if condition X is satisfied or condition Y is satisfied, this is the result. One can readily see there will be instances where both X and Y are satisfied. Nevertheless, it's clear the intention would be that the result would be the same. Doesn't mean that they're mutually exclusive alternatives, but that's not this case. One's not saying here in some sort of condition sense that one's looking at conditions B or C to see if they're satisfied. This is a mathematical formula, and what the formula is saying is that for the qualifying transaction, you calculate consideration capital C by reference to B or C. There's no reason to read or as and in that sense, and every reason not to.
Doesn't it depend what the rest of the words mean? If you were to read the definition of consideration as for a qualifying transaction, and then B, to the extent that transaction includes a sale of shares, blah blah blah.
Yeah.
C, to the extent the transaction includes an option, blah blah blah. Then we're in the same territory. That clearly can be and.
Or.
Yes. I use the word or, but it could clearly mean and in that circumstance.
It could if looked at in isolation. I mean, this was the point that was argued before the judge, that all here is recognising is that there are alternative ways of doing this. But the problem with that is that if one understands it not simply as an isolated definition, but as a stage in a mathematical process. So you have to read that as being, that's the figure then gets fed into the ratchet. And then on the other side of the ratchet, that's the figure that gets prorated down with the stadium premium amount. So if you understand that the or is not simply, it could be this or this, which is I think what is being suggested, but consideration capital C is this or this or this. Then you apply the adjustments. Then you feed it into the ratchet. It has to be only one of the three.
What about the point I raised to Mr. Rabinovitz, that the wording of C seems to anticipate that, that a share option may be only part of a qualifying transaction?
Let's go back to that. Well, in my respectful submission, I understand how your lordship's reading the clause. Can we just go back to it and explain it? The way to read it is, in my submission, if any share purchase option or similar in the club is being sold in that qualifying transaction, I think your lordship reads in that as being as part of. But,
Well, I'm just asking
well,
whether how else would one read it? Because if it was, it could have said, if the qualifying transaction is a share purchase option or whatever, but it doesn't. It says if it's in that transaction.
but it can equally be read as if any share purchase option in the club is being sold in the qualifying transaction, i.e. simply referring to the nature, the essential quality characteristic of the qualifying transaction in question. I mean, take for example a simple just a share option case. One would read that and not say, oh, well, what other aspects to this qualifying transaction were there? One would just read it as saying, well, it's a share option case, and that's what this qualifying transaction is about.
I suppose you can point out that the A uses in that qualifying transaction as well, and that's looking at 100% of the share capital.
Yes, yes. I adopt that. A, B, or C, E, all of them are directed at this stage in the process of working out what the notional value extracted, if extrapolated to 100%. And the reason they do that is because that's the figure that's going into the ratchet. And then at the other side of the ratchet, it's going to be reversed back down again. And it just doesn't make any mathematical sense or commercial sense if you put two lots of 100% in and then have to somehow either disaggregate or apply the A to B ratio and come up with some commercially absurd answer. And 20 million. Now, can I turn to my third heading, business common sense? In my submission, business common sense has no role in contractual interpretation where the meaning of the clause is unambiguous. It's only relevant in the case of ambiguity or the very narrow instance of commercial absurdity. Now, we've accepted that if the clause is ambiguous, we must lose because the expert's entitled to resolve that ambiguity. So one has to ask, where does business common sense take one? They don't need it. They can just say, well, the clause is ambiguous, and therefore the expert's determination governs. But in any event, the point is a false one because the logic is that because the intent of the overage provision is to catch and dispose of any interest, that's paragraph 41(1) of their skeleton, and because our construction would mean that the share option does not attract a stadium premium amount, therefore our construction is not in accordance with business common sense. But as I hope it's clear from my submissions already, our position is not that any share option would be immune. It is simply that it's only a share option where the value extracted exceeds the threshold amount. The word "or" in the definition of consideration is necessary to serve business common sense, because otherwise the distorting effects of the blending, adding together an insertion of more than 100% notional value, will give erratic and perverse results. There is no need for each aspect of the transaction to clear the threshold. And there is no anti-avoidance problem here, or indeed otherwise. What we say is that the argument based on business common sense really just takes one back to the correct meaning of the clause. Because if we are right about the correct meaning of the clause, then business common sense dictates that E20 should get what we covenanted to pay and no more. And if we're wrong, then they don't need business common sense anyway.
I'll just go back to the question of ambiguity, because I think you started off by accepting if there's ambiguity, then you lose.
Yes, I do.
Ambiguity at which stage? If we focus on the words of C in the definition of consideration, if any share purchase option in the club is being sold in that qualifying transaction,
Yes.
there are two possible ways of reading it. One is if the transaction includes, as an element, a sale of a share option.
Yes.
And the other is if the transaction consists of the sale of a share option. So there's an ambiguity on the words. If you have to have resort to business common sense to resolve the ambiguity, does that mean you still lose? Or do you say because you've managed to iron out the ambiguity by reference to some broader proposition, you can still win?
No, I lose.
Right.
If the clause is ambiguous. But the answer to that point is that that's not a material ambiguity, because the unambiguous element of the clause is the words "or" between A, B and C. It's one of the three. I'm sure that one can find ambiguities in this contract. The question is whether they are material to the outcome.
So you're saying that the word "or" is ambiguous?
No, I'm saying it's unambiguous. It's clear that you can only use A, B, or C to be fed into the consideration capital C. For a calculation of the stadium premium amount, there is only one of A, B, and C that can be used, because consideration is defined as either one or the other or the other. And the expert found it was B and C added together. And that's just not what the contract says.
If, this echoes a point I made a few moments ago, if B is to be read as if the transaction includes as an element a share of sale less than 100%, and if C means if the qualifying transaction includes the sale of a share option, doesn't that help to colour what "or" means? Because how can "or" not mean "and or" then? It's a transaction which might include an element in B and in C.
No, because if that's the case, you still have to choose between B or C. And in the case of C, you still then have to value on the basis of the consideration to be paid for the share purchase option. It doesn't permit you in C to carry out some form of blending. If C, what I do agree is that if C was in somehow ambiguous, that meant you're entitled within C to add both the disposal, to do two extrapolations and put them both in C, then I accept the point. But it doesn't. A, B or C are three different notional 100% valuations. And what the expert did, he did not do what my lord is suggesting. He didn't say, I'm looking at C and I'm feeding in the share disposal and the share option into C. That's not what he did. He said, I'm calculating the notional value based on B, I'm calculating the notional value based on C, and I'm going to add them both in. And that is flatly contrary to the word or.
Can I ask, in C, the word of, which the parties are agreed should be read or before the consideration to be paid
Yes.
for the share. Do you say that is or is it and or?
Well, or, that's the agreed position.
But you earlier said that if the option was exercised,
That,
as I understood it, you'd look at the option premium and the exercise price. So I think that's reading it as and or.
well, that may be right. The parties have agreed that the of
Well,
should
you've
be
agreed
or.
that, I think, as I understand what the parties have agreed is that is a typing error
Indeed,
and the word should be or,
indeed.
but that leaves open the question of what it means.
Well, what
Does it mean or does it mean and or?
I'm not sure our concession was based on this is how you read this clause, or simply we would not contend otherwise because we're sensible commercial people and we're in a long-term relationship. So I don't know the precise basis upon which that concession, but it's always been conceded that we can't escape the share premium amount by simply doing an option and then exercising later.
Like business common sense to it, that's the result you come to.
It's just commercially unattractive, and I don't. In my submission, we shouldn't be forensically punished for having made that sensible.
But I think that's
concession.
what I'm I think interested in is if you have an option which is affected, so it becomes a sale at 100%, just like the other sales of shares.
Yes.
Then that sale would be affected, would go into the mechanism just as the 187 goes in.
Yes.
So how then does one factor in the consideration for the share purchase option at the same time? Why does one not regard that as a separate qualifying transaction?
Well, Lord, there are a number of ways in which one could do that. One could either read C as being both together, or one could simply understand that case as being a category B case, i.e. that you've now disposed of the shares and the consideration for the disposal was both the option price and also the strike price.
So there you're reading it as being, that is a form of blending then, isn't it? Of a sale price and an option price.
But not in the sense that it offends the word or. That's entirely consistent with the reading of B. Well, none of these issues arise in this case. I mean, I accept it's a legitimate forensic tool.
Well, in
to
a sense,
say
it does
what
arise, doesn't it? Because if the shares were sold, then it becomes exactly the same as the shares which were sold in this case.
But it doesn't offend the or. Because if you had the option price at, let's say, I don't know, 20,000 per share, and the strike price at 100,000 per share, we have always conceded you add them both together. And if you add them both together under B, you're not offending the word or, and you're not using two lots of 100% notional valuation to inflate the agreed percentage amount.
Yes.
It's common ground that in this case, the price per share in relation to the disposal was £138,000. It's way above the threshold amount if viewed on a per share basis. And it's common ground that the price for the per option was £17,000. which is way below the threshold amount. So there's nothing uncommercial or absurd in saying that the one part of the transaction does attract a share premium amount and the other doesn't. That's, we say, consistent with the ratchet and the threshold amount. Can I move then to look at the cases briefly? We don't agree that all construction issues are solely for the expert and that the court can't review them. I do accept that the more susceptible a construction is to multiple interpretations, the more difficult it would be to challenge. And indeed, I've gone further and said that if a clause is ambiguous, it would be for the expert to determine. But this is a contractual formula, and I do submit to the court that pricing mechanisms and formula like this are in a particular category of their own, because the parties, when they agree to a formula, one should proceed on the basis that they intend at that stage, they are striving to come up with something that is unambiguous, that does not have more than one right answer. And the court should not be too ready to find ambiguity where it's clear that the parties were striving themselves to avoid it. The parties intended, we suggest in this case and also in similar cases, to come up with a formula that would not be the sort of formula that could have two right answers. It is true that the expert has a wide ambit. There are wide ambit of role to interpret the words of the contract, but there's a limit. And the court, this judge, this court here, is entitled to find that the expert's reading of the contract is outside the range of available interpretations. And I would commend that test to the court. Was the expert's approach here outside of the range? One can readily think of examples where an expert's reading of a contract may be outside the range. It might be that an expert that reads up as meaning down, or red as meaning blue. Or in this case, in a mathematical formula, reading or as and.
So
now,
outside the range of available interpretations, what is that from a particular authority?
No, it's not. Well, but I'll show you the court Shafi and Rutherford, which is Court of Appeal authority where there was debate over the construction of an underlying contract.
I mean, outside the range of available options is more of a, sounds almost more like a sort of test one would use in challenging an exercise of discretion or public law challenge.
I didn't intend that. I see the point. But the point is this, if the clause, it's a mathematical formula, if it's clear what the formula means, it's unambiguous, then there's only one right answer. And if the expert didn't get that answer, then it's the wrong answer. And it's manifestly wrong.
Well, this all depends upon it being, you being right to say that the mechanism is clear cut. And I think what we'd be looking at now is your submission that it is, the mechanism is clear cut. And I think that's what we've been debating, isn't it?
I do submit that. Not just, I obviously rely on the or point, but I rely on the scheme of the formula as well. The extrapolation up and then the prorating down, the ratio A to B, the fact that the definitions carry through in a formulaic sense. A means B and then B you add to C is not quite the same as simply a definition of, in a more general sense. Can I briefly consider some of the cases we've looked at and then answer some of my learned friend's specific points? In Vensis, that was a case about calculation of final consideration under a share purchase agreement. And the judge, Mr. Justice Thomas, found that the court could look beyond the face of the determination itself. The test applied at paragraph 44 was obviously wrong, and we don't quarrel with that. Whether one requires argument or not to see what is obvious is, we would submit there's nothing incongruous about saying that the court was assisted by argument before determining that an answer is obvious. But that's really all that events is about. But it's important perhaps to emphasise that that was not a case about the formula being applied. That was a case about the inputs. In many of these cases, the experts not being asked to apply, the dispute isn't about the way the expert applied the formula. The dispute is about the inputs that the expert put into the formula. And Invensis was an inputs case. Weber Oil is slightly different because that's not about manifest errors at all. That's a case about departure from instructions, the testing methodology used in the quality of the oil. And really all that we get from that is Lord Justice Tuckey saying obiter that manifest errors have to be material. They have to have a material effect on the outcome.
I thought it was Lord Justice Simon Brown, wasn't it?
Well, that was the shorthand formulation approval from previous cases. Of
I see. Yes.
But what the case is about was about expert instructions and what methodology used. Walton Holmes. Can we just have a look at Walton Holmes? This is the Justice Peter Smith decision. That's in the bundle at tab 10. This was the planning permission case, and it's not quite as my friend submitted to your lordships. What we would say is, if one looks at start at page 183 of the bundle, paragraph 29 of the judgment is looking at the expert's reasons, and if the court could look at paragraph 21 of the expert's reasons, where the literal meaning of words in a legal instrument leads to commercial absurdity, binding authority requires departure from that meaning. And ICS referred to. Further, the court's powers to substitute other words in order to achieve a non-absurd meaning are theoretically unlimited. No limit to the amount of red pen. So that was the expert's view of the law. If there was a commercial absurdity in the agreement, then the expert could depart from the literal meaning. And then what happens is at paragraph 46, the judge says, about halfway down that paragraph, it does not look obvious when reading his analysis. It is not obvious that he's disentitled from looking to the factual matrix out with the four corners of the agreement. It is not manifestly erroneous for him to do that because the limited construction put forward by Walton produces a commercially absurd result. So that's in accordance with the way the expert directed himself on the law. It is not manifestly erroneous for him to apply the principles in Chartbrook and apply that to the words the permission and come up with a wording which reflects the intent, namely that the parties were to share equally the planning gain obtained in respect to this site. It was not intended for the planning gain to be largely pocketed by Walton, which is the logical conclusion of the application of the literal wording of the agreement. As Lord Hoffman said, something must have gone wrong. These are perfectly acceptable reasons for his conclusion. They're not manifestly erroneous. So it's not right to say the judge was here saying, oh, this is an issue of construction, I'm just not getting involved. What the judge did was analyse the expert's logic, say that the expert's logic was in accordance with the authorities, and therefore his process and reasoning couldn't be attacked as being manifestly erroneous. That's all that Walton Holmes holds, and rightly so. And obviously, when one understands the facts, one can see that it would be commercially absurd to say that the differential in value was the day before the planning decision notice came through. It's not just the benefit of the planning committee indication, by the way, the planning officer's indication, it's the result of the planning committee meeting. That's what was said. So you'd have a planning committee meeting giving planning permission and the value at that level, and then you just get the planning decision notice come through, slightly increases the value. And the expert said that was commercially absurd. And all that the judge here is saying, well, if you look at the authorities, that's in accordance with the established law of construction. So it's not really a surprising result. It doesn't really help. Flow group, this is another inputs case. We didn't really look at it, but it's where we get the howler expression from. It was a working capital adjustment in a share purchase agreement. The business being sole supplier of gas and electricity. And
So which tab are we in now?
so flow group is at tab 16. There were three classes of so-called assets that were under scrutiny, and if I can simplify it, they were situations where gas had been supplied, or gas and electricity, in fact, had been supplied. It hadn't been billed, and it either was or wasn't identifiable to a particular customer. So if one thinks about it, this is really about can you recover as a debt the amount of the gas or electricity supplied when there are certain contingencies applicable. And what had happened was, in the accounts, these had all been recognised as assets, and the expert was asked to value on the completion statement consistent with the accounts. So what the seller said was, look, if you look at the accounts, we recognised all of these as assets. So therefore, consistent with that recognition, that should carry through into the completion statement. But what the expert said is, yes, but things have changed since then, because there's been a letter from Ofgem, for example, that says that you can no longer recover these sums or bill these customers. That was obviously an incredibly fact-sensitive dispute, and one where the expert was plainly entitled to reach the view. What it wasn't was a case where somebody was saying there is no dispute but that the amount should be 100,000, and the expert wrongly included it in the calculation of the completion adjustment, the working capital adjustment. So the expert, for example, deducted an asset rather than added it in. It wasn't a formula type case, as this one is. In this case, there is no dispute about the inputs. Can I just mention Sarah Hussain, because in my respectful submission, Millennium Film was unfair to the judge at paragraph 29 of the judgment. Sarah and Hussain, that's at tab 17. What had happened here was that there was a disputed service charge due under a lease, and the lease contained a conclusive certification provision. It's not an expert determination case, it's where the landlord had certified the service charge, and the terms of the lease said, well, that is conclusive. And what the tenant said is that just can't be right, because what that means is the landlord becomes the judge and jury in its own cause. We must have surely the right to challenge. And it went up to the Supreme Court. And what the Supreme Court found by a majority, Lord Briggs dissenting, was that you could read the clause as being it's conclusive for the purposes of payment, i.e. at the time that the service charge is due, but is not conclusive in relation to a subsequent challenge to the quantum. In other words, it's a pay now, sue later type clause, like an anti-set-off sort of clause. And Lord Briggs thought that you couldn't read those words into the agreement. So when the judge at paragraph 29, go back to paragraph 29 of the judgment, refers to Sarah Hussain, he's not in my respectful submission, not making the point that any friend suggested he was making, which it was said was a fresh error. He mentions Salah Hussein, and then he says, 6 lines down, it's also relevant in my judgment, there was no possible remedy for an aggrieved party other than by challenging determination of the ground of manifest error or fault. All he's saying is, this is not like Salah Hussein. It's just a comment in passing. He never drew any meaningful, any consequential distinction from that. It was not a ground for his decision. All he's doing in passing is saying, in Salah Hussein, one of the points that troubled the court was that unless you came up with a slightly different construction, it would mean that the tenant was shut out forever and all time and challenging their service charges. Lastly, can we look at Shafi and Rutherford? That's a case that we've asked to be added to the bundle of authorities. And that is at tab 12 of the bundle. What had happened here was that there was the sale of a dental practice, and it was actually two dental practitioners, the defendant and the claimant, were in business together, and it was agreed that one would buy the other one out and pay £25,000 plus the value of the net assets of the business. And so there was a completion accounts type dispute as to what the value should be. Now, the equipment that was used in the dental practice, I guess the drilling machine and whatever else they had, was all obtained on leases from a finance company, Braemar Financing. And the court may be aware that in the context of accounting for leases, there are two possibilities in that situation. They can be accounted for as an operating lease or a finance lease, and there are accounting rules that govern which. But there's an important distinction for the purposes of what assets or liabilities go on the balance sheet. Because if a lease is an operating lease, then the liability does not come onto the balance sheet, the liability in relation to future lease rental payments. But if the lease is a finance lease, the debt comes onto the balance sheet. And what had happened was that the accounts, immediately before the transaction, categorised those leases as operating leases. So that had an inflating effect on the asset position. The expert comes along and the expert's asked to value the assets, and the expert forms the view that the leases are finance leases, and therefore the liability should come onto the balance sheet, which made obviously a very significant difference to the price that was going to be paid. Both the judge at first instance found that and what I should say, what the expert did is he said, well, my hands are tied here because the accounts treat them as operating leases, and even though I'm persuaded and I'm satisfied they should be finance leases, I have no way of getting around that. And if one looks at paragraph 20 of the judgment, on the 21st of June, this is before the determination, the expert wrote to the parties. In his letter, he explained he considered the Braemar leases were finance, not operating leases. Thus, their treatment in the company's June 08 accounts, as well as in the draft of completion accounts, was wrong and did not comply with those of the reporting standards. He said that his interpretation of the agreement was that he could not amend the June 08 accounts, yet it was impossible for a determination to be made under the terms of the agreement when the accounts, which are, as he said, the starting point for the agreement, are not FRSSE compliant. He asked for the June 08 accounts to be amended to treat the Braemar leases as finance leases, or for the parties to agree that he could amend the accounts himself to treat the leases as finance leases. The expert's conclusion that he needed to amend the 08 accounts was based on his interpretation of the agreement, namely that he was bound to treat the leases in the way treated unless and until the company's 08 accounts were amended. This was the point that frequently in these transactions, there's a requirement that completion accounts are consistent with the previous accounting policies. Paragraph 22, on the 4th of July 2011, the expert issued his determination. His findings were: 1, he discussed the matter with the Braemar leases with the company's accounts who now accepted they were finance and not operating leases. 2, his determination was accordingly that the Braemar leases were finance leases and the 08 accounts had not been properly prepared under FRSSE. 3, there was no mechanism under the agreement for him to amend the 08 accounts, although they had not been improperly prepared and according to him formed the basis of the agreement. Accordingly, he could not take account of any lease liability. And if one looks at then paragraphs 26 and 27, 26, the main issue between the parties therefore concerns the proper construction of paragraph 1.4 of Schedule 4. That's the clause that requires completion accounts to be drawn up in accordance with previous accounting policies and the like. The appellant says the expert was right to interpret him as requiring to treat the Braemar leases in the same way they've been treated in the 08 accounts. The respondent says the expert wrongly interpreted his mandate or instructions. Paragraph 1.4 did not require him to carry forward an incorrect treatment of the Braemar leases. 27, the deputy judge concluded that paragraph 12 of the judgment, the question of how the Braemar leases would be categorised and the impact of that upon the completion liabilities was a matter which came within the scope of the expert determination, in particular paragraph 1.1. So in other words, the expert was entitled to interpret his role and clause 1.4 of the agreement. That was part of his remit. Nevertheless, over the page, paragraph 27.6, judgment paragraph 17, the expert had committed an error in considering he was prevented from embarking on the task of applying the correct policy. This was an error in interpreting his jurisdiction, or putting it in a different way, was a material departure from the scope of his instructions. The error justified the intervention of the court. The judge was, if necessary, prepared to have gone further and hold the expert committed a manifest error. And then if one looks at the Court of Appeal's reasoning, paragraph 35, there is analysis of the construction of the contract. And then 39, I think without intending the least disrespect to Mr. Latimer's well-sustained submissions, the question can be asked and answered at a rather higher level. What, against the relevant factual background, were the parties using the language of paragraph 1.4 to mean? Did they mean the liabilities of the company should be computed by reference to correct accounting policy, supplemented if necessary by reference to practices adopted, or did they mean that they should be computed according to such policies except where contradicted by the actual treatment of those liabilities in the 08 accounts, whether that treatment was right or wrong? In my judgment, the judge, first instance, was right to accept the first of those alternatives for essentially the reasons he gave. The completion accounts were to provide the final adjustment between the parties and consideration for the sale of the shares. For my part, I can see no reason why in those circumstances they would have wished to carry forward erroneous accounting treatment of liabilities. Rather, they would have been seeking to reflect, at least so far as the liabilities are concerned, the reality of the situation. It's true that the agreement had started off from a roughly negotiated figure of 136,500, from which the liabilities were to be deducted, and that it may have been the case that reliance by the parties was placed to some degree on the company's accounts in arriving at that figure. Whether they did, in fact, we do not know. But like the judge, I do not find that consideration as compelling as the considerations which favour the respondent's construction of the agreement. There was no dispute that if the expert was wrong to conclude these computations were constrained the way he concluded they were, then this was a case in which it was appropriate for the court to intervene. It's therefore not necessary to decide between the alternatives of misinterpreting jurisdiction and manifest error. Now, it's true to say that the court did not say, as the judge had found, that this would have satisfied the manifest error threshold, but it is clear that the court was prepared to look at the agreement in question, was prepared to find what the correct construction was, and didn't hesitate to intervene when they thought that the expert's approach was wrong, plainly wrong. The words I've suggested, outside the range of permissible answers an expert could give in that situation. Now, if it's said against me, well, that's only a case about interpretation of instructions. It's not a case about, like this one, about manifest error. It would be a very odd state of affairs indeed if the court adopted a vastly different approach to the question of whether an expert had strayed beyond their instructions to manifest error. Now, I do accept there is a materiality distinction between the two. That is clear in the authorities. But if this court finds that Shafi and Rutherford is meaningfully to be distinguished from this case, then all that's going to happen is anybody challenging an expert determination will simply reformulate it as being, oh, this was the expert going outside his instructions. Because it's obviously the case that experts instructed to act in cases like this are instructed to value the contract, value the thing in accordance with the agreement. So it wouldn't be very difficult to simply repackage the case as being a departure from the instructions type. Can I very briefly deal with the second of my learned friend's submissions now? I'll just move on to some bullet points in answer to his submissions. He said that the test is so high that the error must be apparent without not just extensive investigation, but also without adversarial argument. We say that is not consistent with the authorities, but in any event, that's not the general law. It places the tests far too high. All of the cases we've looked at, there was adversarial argument. But in any event, even if he's... I should say this point is not foreshadowed in his skeleton argument, so I have to deal with this effectively on the hoof. I don't accept that's the general law, but even if it was the general law, it wouldn't apply in this case, because in this case, there was agreement that the process of determination would be a full adversarial process. In the supplemental bundle, there were pleadings, a statement of claim and defence. There were then skeleton arguments submitted to the expert and then full oral argument. So even if it's the case that as a matter of general principle, manifest error excludes cases where you have adversarial argument, it cannot apply in this case because the parties themselves agreed that there would be full adversarial argument before the expert. So it must carry through to any subsequent hearings.
Well, the test from the Supreme Court seems to be that there can be limited investigation. And when it's a question of interpretation of an agreement, it's difficult to see how you could have the limited investigation without adversarial argument.
Well, yes, and take this example. Lord Hamlin there had in mind that not a full-blown trial, which of course we agree with. We had one day before the judge and we had one day before. But take this example. Say there is a formula in a contract that's actually really genuinely complicated with all sorts of mathematical notation that the ordinary judge would not feel comfortable in interpreting. Is it really to be said that if the expert simply says the answer is 100 million, that it's not open to the side to say, well, if you actually pick this apart, he's just got it wrong? And that may involve some sort of thought, it may involve some unpacking of the formula and understanding it. That doesn't mean to say that there isn't, at the end of the day, you can't establish a manifest error in the course of that process. My learned friend says that you can't look at the issue of construction first before going on to decide whether the error is manifest. That's paragraph 35 of the skeleton argument. Well, we submit that can't be right. If that's correct, it would mean that provided the court found that some element of contractual interpretation was involved in the expert's decision making, the court had no supervisory role whatsoever. So it would mean that an expert who read the words backwards as forwards would be invulnerable to challenge. But that's not the bargain. The bargain the parties struck is that the expert determination is binding, valid, unless it's governed by manifest error. And the court always retains a supervisory jurisdiction to assess whether an error is manifest. And it's perfectly permissible to look at the error first and decide whether there's an error at all, and then go on to evaluate it. And we suggest that's the case for three reasons. Firstly, it's a matter of common sense. One cannot really assess whether an error is manifest before at least understanding the nature of the error that's being alleged. Not all errors are created equal. If I can put it this way, in order to evaluate, one must first appreciate. Secondly, such an approach would effectively oust the court's supervisory jurisdiction, where the parties clearly intend that the court will have a residual role in that sense. And even the appellants accept that some mathematical mistakes may be manifest errors. I mean, if an expert added two figures together that were supposed to be subtracted, can the expert escape challenge by saying, well, that was just the way I read the contract? We say not so. We say that would be a clear-cut error. And whilst much more simple than this case, is nonetheless, this case is, when one unpacks the formula, is clear-cut. And thirdly, it does not mean, as my learned friend suggests at paragraph 36.1 of their skeleton, that the court has set out to determine the issue of construction. The court may find, as Mr. Justice Peter Smith indicated he might have done, that there's a construction that may have found favour with the court, but nevertheless find that the expert's view is at least arguable and therefore it's not a manifest error. Just briefly on anti-avoidance, I think I've dealt with this. There is no anti-avoidance problem here. There was not on the facts of this case, and there isn't on the formula when one understands it. Importantly, the expert didn't decide the case on that basis. He didn't say either there was in fact an attempt by my client to avoid the effect of the clause, or that was why he was coming to the conclusion he did. Thirdly, just very briefly, a point about discoverability. This point about, well, if it's not in me, it doesn't leap out of the page at you, then it can't be a manifest error. We submit that the quality of whether an error is manifest or not is objective, obviously. And sometimes one does need a bit of thought and unravelling of a provision to work out whether the answer was right or not. Everything depends on context. Pricing mechanisms are a particular type of contractual provision. Most disputes about pricing mechanisms are in relation to the inputs into the formula. Flow Group, Evensis, Walton Homes, they're all input cases. But in this case, the inputs were not in dispute. Well, just if I draw all this together, we say there's 6 reasons why, when one looks at it, this was a manifest error. First is this: the scheme of the calculation, the whole grossing up and then prorating down, simply falls apart if you start adding in more than one 100% notional value of the club. Secondly, the word or in the definition of consideration cannot be read as and, because that's a stage in a mathematical formula. It's not simply saying, for the sake of a definitional provision, oh, well, the consideration might be this or this. What it is saying is that when you are feeding these figures through in this process, the consideration that you choose, the number for the consideration that is fed through to the adjusted consideration, which is fed through into the agreed percentage amount, which comes out the stadium group, that is one of 3 alternatives. And there is just no way around that without creating absurdities. Thirdly, there's the arbitrariness point of, if it's read in the way that the expert read, and indeed my learned friend says should be read, then it gives rise to this arbitrariness in the order in which one disaggregates. Fourthly, the disaggregation process itself from the A to B ratio just simply doesn't work if you add both B and C together. The ratio A to B will give rise to an absurd result of 20 million, which not even E20, London Stadium, have ever contended for. Fifthly, there is a complete absence of any contractual justification for this blended approach. This was something that the judge found very persuasive, and in my submission, this court ought to also to find persuasive. And sixthly, the expert was obviously wrong to say that his determination of whether it was a qualifying transaction or not was determinative. that it was common ground that if we lost on that point, we lost overall. I made it absolutely clear in submissions before him that the formula point, the double counting point, was a freestanding point, and that it was well open to the expert to find it was a single qualifying transaction, but nevertheless still had to apply the formula. And if one's looking for points that jump out at one on the face of the determination, that is one such point, because it's clearly contradicted by the note of the proceedings before the expert. I think that those are my submissions. I'm grateful for them.
Thank you very much.
Hey, my lords, trying to be brief. I've realised most of my points involve saying, my lord or my lady, we're right when you identified X or Y. But perhaps I can just begin with this. In terms of what is common ground, my learned friend took the court to two parts of the expert's determination. Paragraph 38, sorry, first paragraph 12, so we're in the supplemental bundle. Paragraph 12, page 5. Came up this morning with my lady, Justice Falk. Dispute relates to whether the grant of the consideration falls to be treated as forming part of the same qualifying transaction under which 187 million was sold. No dispute that if the 18 million paid for the grant of the option falls to be treated as forming part of the same qualifying transaction, then 3.6 million is payable. And my learned friend also referred the court to paragraph 38 at page 64. No dispute between the parties as to the effect of the option agreement being treated as part of the qualifying transaction as the sale of shares. The additional sum of 3.6 million must be payable. Now, my learned friend took the court to a note, an agreed note of the expert's determination. He took you to page 49. What he didn't do was to take you to page 45 of that note, and perhaps I can just invite you to go there.
Tab 6.
Behind tab 6. They're just picking up with Mr. Pluman's submissions about halfway down the page. West Ham United are right to say 18 million must go somewhere, but they're wrong to say it's disregarded unless and until the option is exercised. Our calculation is based on the purchase of 187 million for 25 million pounds. Makes no sense for the 18 million to be treated differently, etc. We say, just jumping a paragraph, we say you add it to the other consideration received in that deal. This gives a figure of 535 million for the price for the total shareholding. This is got by adding the 475 for the 100% share price for the 187 shares sold to the 60.5 million for the 100% share price for the 1,022 share option. Taking this price for all the shares, there would be an SPA of 12 million pounds if it had been a QT involving all the shares. This is then prorated down. It is all in the 20% bracket and gives the SPA of 3.6 million for the option fee. And then you have this, and there is no dispute on this part of the calculation. If it is right that the option comes within the share sale, correct. If they are right on how the option is treated, there is no dispute. In my respectful submission, the expert actually recorded it correctly at paragraph 6 and paragraph 12 and paragraph 36. There was an agreement that if there was a single qualifying transaction, that was the correct figure. And that matters to a number of the points that my learned friend sought to make in that regard. The next point I was going to make is this. Goes back to perhaps the key point in the case. Was there one qualifying transaction or more than one qualifying transaction? Indeed, what is my learned friend's case about that? The court will recall it was quite difficult to pin my learned friend down as to whether there was a single qualifying transaction or two qualifying transactions. And I'm not sure that the court ever did pin my learned friend down, save to perhaps reach the point where my learned friend said that what one actually has to do is to look at the definition of consideration and then argue backward, not argue backwards, but in an iterative way, go back to the qualifying transaction and conclude that it was more than one qualifying transaction by virtue of the definition of consideration, and in particular the word or in the definition of consideration.
Possibly, as I understood it, you either argue back to say, well, that must mean there's more than one qualifying transaction. Or if there's one, it's only one, it's seems to me the only option is that you somehow have to choose which of the paragraphs of the definition of consideration
Right.
you're going to treat as the consideration for the
Okay.
single qualifying transaction. Because it was said to us that there is another freestanding point, not just the
Yeah.
multiplicity.
So the choice point involved, I think, Malone and Friends saying that if you're in C, which appears to be dealing with options, and the option is exercised, then you should, I mean, this was part of it, I think, you revert to B, because you then have a share sale. With respect, there's no mandate for that in the definition, nor is there anything which suggests that if you are in a situation where you have two elements, that you have to choose as to which of those elements you're going to value. With respect, that depends very strongly on the word or being unambiguous and having the meaning for which my learned friend at one point was contending. But with respect, my learned friend's submissions in relation to the unambiguity of the word or ran into a great deal of difficulty before your lordships. Number one, as my Lord Zacaroli made the point, and I think my Lord Justice Phillips had made the point earlier, it's perfectly possible to read B and C as applying so that if you have one qualifying transaction which has two elements, where one element is a sale, you apply B to that element, and where another element is an option, you apply C to that element. That is giving or the meaning and, but it makes perfect sense. There's no difficulty about that. And indeed, even if that's not completely clear, in my respectful submission it is, because that's the conclusion the expert came to, it's certainly not unambiguous. And there was a point in my learned friend's submission where he appeared to be willing to accept that it wasn't unambiguous. My learned friend is willing to accept that it was not unambiguous. I think he conceded at a different part of his submissions that he would have to lose. And in our respectful submission, that's precisely what should happen. Nor was my learned friend to deal with the point my Lord Justice Phillips made to him, which is once you substitute the word of for the word or in the last sentence of C, as my Lady Justice Falk made clear, it's absolutely plain that that or has to be read as an and or. That's the only way in which you could conceivably read it. My learned friend says, well, they conceded it because it makes sense. With respect, he ought to have conceded that the or between B and C meant and or as well, because that makes commercial sense. But it is very difficult to say in a single definition that sometimes the word or means and or, but on other times it cannot mean and or at all. The court will recall that when my learned friend took you through his Appendix A to show you what the expert did, I intervened slightly to say that we don't accept that that is what the expert did. Can I, for these purposes, rather than take you through this, direct the court to two things. First, what the expert, to what the judge said the expert did. And in our respectful submission, he accurately identified what the expert did. In particular, at paragraph 47 and also paragraphs 52 to 56 of the judgment. That's between pages 80 and 81. And if the court looks at what the judge explained to the expert did, you will see precisely what he did. And it's not the calculation that my learned friend suggests, which no doubt was intended to suggest this cannot be right and it's absurd. But if you look at the way the judge correctly recorded what the expert did, that is rather different. I'm happy to take you through that now, if it will help. Would it help to take the court through it? Okay, my learned friend saying yes, but I'm not sure the court is saying yes. Perhaps since my learned friend sat down early, if the court will bear with me, I'll show your lordships and your ladyship what the learned judge said about this. So if we go what the expert did, we say stage one was to calculate the stadium premium amount that is referable to the sale alone. And for this, if you open the judgment at page 79, call by page 79. This is set out in paragraph 47, little 5. Take the number of shares sold as being 187, that's in 47.2. The price paid per share was 138,162. Total number of issue shares was 3,438. The expert calculated the total implied equity value of the club by multiplying 3,438, that's the total number of shares, by the price for which each of the 180 shares was actually sold. And as the learned judge explained, that produced a figure of about £475 million. That's
exactly the
so
figures
far,
that
so
are
good. My learned friend doesn't need to worry about it. So far, so good. It's only when we get to the later stages. And you see that at paragraph 47.5. If you then that 475 million figure is the adjusted consideration for the share sale, and if you look at paragraph 47.6 at page 79. You see that the learned judge helpfully described this as the share sale adjusted consideration. The expert then fed that figure, the 475 million, into the ratchet in order to determine the agreed percentage amounts. And that gave a total of 46 million, which you can see at paragraph 47.9 on page 80. There's a page, so far so good. That is the agreed percentage amount, but that of course is referable to the 3,438 shares, so not the 187 shares actually sold. So what you then see is the expert prorated the agreed percentage amount back to 187 shares, and subparagraph 47.9 of the judgment at page 80 explains how he did that. And so far, that is in accordance with my learned friend's note. That gives you a figure of 2,532,541, and that's all the share sale agreement. As for the option, this is where we start departing from what my learned friend said. The expert performed the following calculation. The number of shares subject to the option, as the court knows, was 1,022, and the option premium was 18 million. So that's just picking this up in the judgment. The price payable for the option per share, as it were, was 17,612,552, and you see that at paragraph 52.1 of the judgment, page 81. The expert then calculated the total implied equity value of the club in the same way as he'd done for the sale. That's to say, he multiplied 18 million by 3,438, and he divided it by 1,022, and that produced a figure of 60,551,859. And you see that the learned judge describes that as the option adjusted consideration. That's equivalent, and it is the equivalent for the option of the 475 million, which the learned judge described as the share sale adjusted consideration. Now, the 60 million on its own was below the threshold amount, but the expert, because he considered this part of the same qualifying transaction, treated the 60 million as additional consideration, received over and above the 475 million that was attributable to the sale. And on that basis, the expert ran the 60 million through the ratchet, but at the highest level. And he did that, as the court will appreciate, because the highest level of the ratchet applies to the adjusted consideration in excess of 300 million adjusted for inflation. And you can see that at page 112. I'm not sure you've seen, I think you've been taken to that. Now, the percentage level applicable at that level is 20%. And so the expert took 20% of the 60 million figure, which produced a figure of about 12 million. You can see that in paragraph 56 of the judgment. Then over the page, he prorated the 12 million figure, and he did that by reference to the 1,022 shares rather than the 187 shares, because this part of the consideration is referable to the option, and that exercise produces a figure of 3.6 million. So he doesn't just add it onto the top. He does a separate calculation, two separate calculations, and adds the conclusion together.
I don't think it makes any difference, does it?
Well, I'm not sure that it does, but it may just
Same
look.
calculation.
In our respectful submission, done in the way he actually did it, it makes perfect sense. There is no difficulty in seeing why he thought that was the right way of doing it. Well, that's what we would say, obviously.
Yes. Well, there we are. I think sometimes you can rewrite mathematical equations in different ways, but it's still the same equation.
Fair, I'm not going to push back on that. I think the final point I would, well, two more points. First, in relation to the authorities, my learned friend referred the court to Shafi and Rutherford for what appeared to be a slightly different test. And at the end of it, he suggested that although this was a case about instructions, you would expect exactly the same approach to be taken with manifest error. In my respectful submission, that is not correct. Where you're dealing with instructions, clear law that if you don't follow the instructions, it's not binding at all. And therefore, you would expect a very detailed analysis to be conducted in relation to what those instructions were. When you're looking at manifest error, the issue that you're looking at is a completely different issue. And you've seen from the authorities why they take the view that they take, that it has to jump out at you and be obvious. My learned friend also said, in relation to the point about adversarial argument being excluded, and I don't want to push this too far, partly because I can see it's not landing terribly well, but I can also see that depending on how you look at it, it may look extreme. But I just want to be clear where that comes from again. That comes from Lord Diplock in the Nemo in relation to whether something is obviously wrong. And the courts have plainly drawn the analogy between something being obviously wrong and there being a manifest error. I think
So I thought you told us that the authority was the Australian authority.
the Australian authority adopts the Nemo. So the Australian authorities were, before this, you have in Inverness, Mr. Justice Thomas, seeing the analogy between section 69(3) and manifest error because the test is so similar. But it's the Australian authority, I think there was a case called Hogben in Australia, which is the one cited in expert group. Hogben comes up with a formulation of excluding adversarial argument by reference to the Nemo. So in Australia, they followed through on the analogy, at least in the Hogben case, and adopted as part of how you look to see whether there's a manifest error, the idea of asking whether you needed adversarial argument in order to establish the point.
I mean, that may come from the fact that section 69(3) considerations are normally done by the commercial court judge sitting in his room.
That's fair, but of course your lordship is right, that is how it's done. But as a general view as to whether you are looking at something which is obviously wrong and a manifest error, effectively saying if you look at it and it looks as if it is arguably right, you don't give permission. You don't need, if it's something where you think you're going to need adversarial argument in order to get to the conclusion, then it's not obviously wrong. That's all he's saying. Anyway, I know you don't love that particular part of my argument, so I'll rely on all the other limbs of this. And just on that, perhaps this is the last point I would make. Your lordships have been entertained this afternoon by a debate with my learned friend as to the meaning of the word all, as to the definition of qualifying transaction, and as to whether the approach taken by the learned judge was or was not correct. And if the court reflects on whether that was an exercise where you were dealing with a problem which was easily demonstrable without extensive investigation, or whether it was obvious, the point was obviously wrong and allowed of no argument, then in my respectful submission, it's pretty clear what the answer to that is. It wasn't easily demonstrable. It couldn't be demonstrated without extensive investigation. It wasn't a situation in which the contrary argument was unarguable, or where something had obviously gone wrong. And if your lordships and your ladyship are with me on that, then again, the court should conclude that there was no manifest error, even if the court thinks that you prefer the interpretation of the learned judge to the conclusion reached by the expert. Subject to the court having any points that they want me to address, those were the only points I was going to make in reply.
No, thank you very much. Well, thank you to both parties, not only to counsel but to those sitting behind, all of whom we know have a part to play. We will reserve our judgments and we will provide drafts in the usual way for you to correct our typing errors, etc., not for re-argument. And you know only too well by now about the embargo which is placed upon the draft and which we take very seriously. We'd ask the parties to attempt to agree a draft order when they have the draft, and if you can't agree on any aspects, then let us have submissions in writing, and hand down will be electronically, remotely, and no attendance required. Thank you very much.
Rise if able.